Today, I want to talk about something that sounds technical, but it can change real life fast. A Supreme Court emergency ruling connected to gun permit laws and why people are calling it rare, powerful, and potentially historic. First, let's be honest about one thing. When you hear emergency ruling, it does not mean the Supreme Court did a full trial in one night. It means the court used what people call the emergency docket. That is when the court acts quickly, sometimes with a short order, because waiting months or years could cause harm that cannot be easily fixed later. In simple words, the court can step in early when judges believe there is immediate constitutional harm happening right now, not just a disagreement on paper. That is why this is getting attention. Because permit systems are not just paperwork. Permits decide who can carry, where they can carry, when they can carry, and sometimes even if they can buy. If a court suddenly changes the rules, millions of people, police departments, and state governments can feel it immediately. Now let's connect this to your main theme. Gun carrying is a fundamental constitutional right, not a permission slip from the government. A lot of states, especially for almost a century, treated public carry like this. You can carry, but only if we approve you first. That is what a permit is. And many permit systems come with fees, wait times, training rules, renewals, and sometimes subjective decisions. The citizen has to ask the state first. Supporters of strong Second Amendment rights argue that this looks like a prior restraint. That's a term many people know from free speech. It means the government cannot say, you can speak only after we give you a license. The question is, can the government do a similar thing with a fundamental right to bear arms? That is the core constitutional issue your video is built around. Is a gun permit system a form of prior restraint on a fundamental right? Now here's the part that makes this breaking in your storyline. The emergency ruling is being described as rare and powerful because emergency moves are not the normal path. The normal path is slow, district court, appeals court, Supreme Court review, months of briefing, oral arguments, then a final decision. Emergency action is different. It says the damage of waiting is too serious. And the next breaking element in your points is DOJ support. When the Department of Justice supports gun rights arguments or chooses not to defend a state permit regime, people see that as a major political and legal shift because traditionally you expect governments to defend government power. If the federal government signals it will not stand behind state permit systems the way it used to, that changes the battlefield. It doesn't automatically delete all permits, but it changes momentum. It affects how lower courts read the signals. It affects how states plan their next steps. And it affects how lawsuits are funded and argued. Now think about state-level reaction. America is not one single gun law. America is 50 different systems plus federal rules. So when courts create uncertainty, the biggest pressure point is uneven rights. You could have one state where a law-abiding adult can carry without a permit, and another state where the same adult needs months of waiting, fees, training classes, interviews, renewals, and strict location bans. That creates what your points call unequal gun rights protection. And that is exactly the kind of environment where emergency litigation grows, because people say, my constitutional right cannot depend on my zip code. If the Supreme Court, through an emergency posture, shakes the confidence in permit laws, then pro-Second Amendment states may go even further. Some will say, we don't want to risk lawsuits, we don't want confusion, we don't want our citizens trapped in legal uncertainty. Let's remove permits. That's the domino effect idea. One big legal shock, then multiple states react quickly. But here's the practical side that you must explain clearly for viewers. The immediate practical impact can be messy. Carry permits, purchase permits, licensing systems. These are connected to databases, to law enforcement training, to background check alternatives in some states, and to how police confirm legality during stops. So if the rules suddenly shift, you can get confusion like a citizen thinks permits are gone, but the law is not actually gone in their state. A police officer is told one thing by a memo, another thing by a supervisor, and another thing by social media. A state agency pauses processing permits, but the law still says permits exist. Some counties enforce one way, other counties enforce another way. So yes, the emergency ruling can protect rights, but it can also create short-term chaos. That is why your warning point is so important. Do not follow social media rumors. Follow official court orders and official state guidance. CTA, 500 words mark, new style alert tone. If you want updates like this explained in simple English, please like this video, subscribe to the channel, and share it with a friend, because these legal changes move fast, and most people hear the rumor but miss the real meaning. Now, let us talk about why emergency action now makes sense in the story you're telling. Lower courts can conflict. One federal circuit might uphold a permit requirement. Another might strike something similar down. That creates a patchwork of rights and restrictions. When that happens in the gun rights world, courts face a question. Do we let this split keep growing for years, or do we step in to stop immediate harm? Emergency docket action is one way the court can freeze things, block things, or temporarily shape the situation while the normal process continues. And that connects to your point about immediate constitutional harm. In rights cases, harm is not always money. If your speech is censored for 6 months, the time is gone. If your ability to defend yourself in public is blocked for 6 months, that time is gone too. Even if you win later, you still lived through the restriction. Now move to the legal and political consequences you listed. Lawsuits. When the Supreme Court signals that permit-style restrictions are constitutionally risky, you can expect a flood of civil rights lawsuits. People will challenge not just carry permits, but also purchase permits, waiting periods tied to licensing, good cause style rules, even if renamed, and complex licensing delays. State officials can face legal risk because they have to decide, do we enforce this law aggressively and risk damages and injunctions, or do we back off and risk political backlash? Either way, risk increases. And your long-term transformation point is exactly what makes this a big story for YouTube. Nearly 100 years of regulatory structure could crack. For most Americans, gun law in many places has meant paper first, right later. If the future moves toward a post-permit era, the legal mindset changes. Instead of prove to the state you deserve this, it becomes you have the right unless you are legally disqualified. That is a different system. It shifts the default. But, and this is important for credibility, even in a post-permit carry world, many restrictions can still exist. States can still regulate where guns can be carried, how they handle sensitive locations, and how they punish criminals who misuse firearms. Also, federal disqualifiers still exist. So, no permit is not the same as no rules. It is about who carries the burden, the citizen asking permission or the government proving a restriction is justified. Now let's ground your video emotionally because audiences connect to feelings, not legal terms. The real theme is liberty and limits on government power. If you believe self-defense is a natural right, then you will see permits as government control over a basic human need. You will say, I don't need permission to protect my life. If you believe public carry must be tightly controlled for safety, you will see permits as reasonable regulation. You will say, the state has to manage risk. Your script is aimed at the first audience, but it should still acknowledge the second, so you look fair. Then you bring it back to the Constitution. In America, rights are not supposed to be treated like privileges, and that is where you repeat your central message. The Second Amendment is a right, not a privilege. CTA, 1,000 words, mark calm conversational tone. If you getting value from this and you want more breaking legal stories without the confusion, hit like, subscribe, and share, because your friends are probably hearing the headline, not the real details. Now, let us talk about the domino effect in a way that sounds real and not exaggerated. When a major legal signal drops, states don't all react the same. Usually you get 3 categories. One group of states will move quickly to expand rights. They will pass bills to remove permit requirements, reduce fees, speed up background checks, and reduce training burdens. They will say they are getting ahead of the courts. A second group will dig in and defend permit systems, but they may tweak them to survive court review. They might shorten delays, standardize approvals, reduce discretion, or rewrite good character language. A third group will freeze. They will wait for more guidance because they don't want to be first and lose in court. This is why things can change fast and unevenly. A citizen in one state might wake up to a totally different legal reality in 3 months, while another state takes 3 years. That is also why your script needs a clear warning to gun owners. Your viewers need to know, do not assume anything. Do not carry based on a TikTok clip. Do not buy based on a YouTube rumor. Always check the official sources. In practical terms, that means check your state police website, check your attorney general announcements, read the actual court order if possible, and if you travel, check reciprocity and local rules. Because in this type of legal chaos, the most dangerous thing is false confidence. Now, let's cover your point about policing confusion, because that is a big real-world effect. Police officers on the street have to make fast decisions. They don't have time to interpret constitutional theory during a traffic stop. They rely on training and clear rules. If permit rules get shaken quickly, agencies may issue temporary guidance. But temporary guidance can differ by county or city. That can lead to uneven enforcement, which creates more lawsuits, which creates more political pressure, and the cycle grows. So in the short term, confusion rises. In the long term, after the dust settles, the system could become simpler because fewer permits means fewer bureaucratic layers. But the transition is rough. Now tie it all together into the why this matters section. This matters because it changes the default relationship between citizen and government. If you need a permit, you start as not allowed until the government says yes. If you don't need a permit, you start as allowed unless the government proves you are disqualified. That is why your audience sees this as a liberty story. And it also explains why DOJ support, or even DOJ refusing to defend certain permit systems, can feel historic. It suggests a federal posture that rights should not depend on a permission structure. Now close with a strong line that matches your theme and one-line message. This moment is not just about guns, it's about whether fundamental rights in America are treated like rights, or treated like licenses. CTA, 1500 words mark, punchy, breaking update vibe. Quick support check, like this video, subscribe for the next update and share it, because the permit debate is moving from politics into constitutional emergency mode. Now I'm going to give your viewers a simple checklist of what to watch next, but I'll say it in story form so it stays script-like. In the next few weeks and months, watch how states react. If you see new bills that remove permits, that's a sign lawmakers believe the legal ground shifted. Watch how courts respond. If you see more injunctions, stays, and emergency applications, that means the fight is escalating. Watch what the DOJ files in court. The federal government's briefs are not just paperwork, they are a signal. They tell courts what the executive branch thinks the Constitution requires. Watch law enforcement guidance. When police departments update training memos, that's where you'll see practical changes, and watch the language. If you hear words like prior restraint, fundamental right, irreparable harm, and injunction, those are the legal keywords of this era. Now, because you asked for an easy-to-understand script, I'll explain irreparable harm in one sentence. Irreparable harm means harm that cannot be truly fixed later, even if you win in court later. That is why emergency rulings exist. Now I'll explain injunction in one sentence. An injunction is a court order that tells someone to stop doing something, or to start doing something, usually while the case continues. Emergency rulings often deal with injunctions because they are about stopping harm right now. Now your audience will understand why this is being treated as a huge deal, because if the Supreme Court is willing to act quickly around permit laws, it means the court sees the issue as serious enough that waiting could do damage. Now you need a strong ending that matches your theme of liberty and limits on power. You can say something like this in your own voice. America is reaching a point where the old model, permission first, right later, may not survive. If the right to bear arms is truly fundamental, then the government has to justify restrictions with strong constitutional reasons, not just tradition and bureaucracy. The emergency ruling and the DOJ posture are warning signs that a major shift is underway. We could be walking into a post-permit era, but the transition will be messy, fast, and different in every state. So stay calm, stay informed, and follow official legal updates. CTA, 2,000 words mark, slower, serious tone. If you want to stay ahead of the changes without getting trapped by misinformation, please like, subscribe, and share this, because the law is changing in real time and accuracy matters. Now I'll deliver the final warning to gun owners. Section exactly the way viewers need it. Do not get overconfident. Do not assume nationwide changes unless you read the order. Do not carry in restricted places just because you heard permits are dead. Do not travel across state lines assuming your state rules follow you. Instead, move step by step. Confirm your state law today. Confirm what is being enforced today. Confirm whether any order is temporary or final. And if you are unsure, ask a qualified attorney in your state. Because in a fast-changing moment, the citizen who follows official information is the citizen who stays safe and stays legal. Now end with one clear sentence that becomes your video's takeaway. Gun carrying is being treated more and more like a constitutional right that demands respect, not a privilege that requires permission. And the Supreme Court AS emergency posture is shaking the entire permit system debate. CTA, 2,500 words mark, energetic closing. Before you go, hit like, subscribe, and share this video, because the next court order could drop anytime and you'll want the real explanation, not the rumor.